Thank you. Deputy Gilmore.
First of all, I wish to thank my colleague, Deputy Howland, for bringing this bill back before the House, and I want to thank all of the members of the House for their contributions, and in particular those who have expressed support for it. Chairman, Deputy Cuff, I don't in any way dispute your own personal commitment, or indeed that of your colleagues, to the bill that's before the House. And I want to assure you that this bill is back before the House, not to in any way embarrass you or cause you any political difficulty. Because if one looks back over the history of the measures which have been proposed by the Labour Party in this House to modernise our laws and to liberalise the way in which we run our affairs, we've introduced those measures back over the years on their merits. Legalisation of contraception, the issue of divorce, the decriminalisation of homosexuality in the 1993 period, and this bill again. But I do say, Chairman, that you and your party have been hopelessly outwitted and outmanoeuvred by your far more experienced Fianna Fáil colleagues, who are pursuing an agenda on this issue that is a lot closer to the reactionary comments that were made here by Deputy Mansur than they are to the views that I know that you hold. The truth is that you have been sold a pup and you have been outwitted on the issue. The commitments that you have got are virtually meaningless and are actually a retreat from what was an offer from the then Minister for Justice, Michael McDowell, back in February of last year. At that time, Minister McDowell sought a deferral of the second stage of our bill for a period of 6 months with a view to enabling a more comprehensive approach to the question of civil partnership to be adopted by this House. The government amendment on this occasion, to which you have subscribed, if passed, will simply kill off the Labour bill and kick the issue into the indefinite future. Now, Chairman, I heard you this morning on radio trying to explain this. And you sought to take credit on behalf of your party, the Green Party, for the production of heads of a bill by next March, and you sought to represent that as somehow a great victory on this issue. Now, either you are being incredibly naive in selling that line to the public, or you're simply trying to sell on the pup that you yourself have been sold. Firstly, because if the March deadline is so significant, then why isn't it included in the government amendment that is before the House today? Secondly, anyone with even a passing knowledge of how the legislative system works knows that there can be a huge interval between the heads of a bill being agreed and the legislation actually being published, never mind being enacted. And if I can draw your attention to one example. On the current government's legislative programme, there is a bill, the Ombudsman Amendments Bill, the heads of which were agreed in autumn 2003. This is autumn 2007, and the bill has yet to be published, much less to be enacted. Now, where you made your mistake, I understand, of course, parties in a coalition government, you have to agree, and you have to accommodate to the real agenda of your government partners, which was expressed here by Deputy Mansur earlier today. But you made a fatal parliamentary mistake. The amendment that you should have brought before this House was an amendment to restore the Labour bill to the order paper and then do whatever it was you wanted to do about the committee stage. If your real position was, well, we're preparing our own bill and we're going to introduce it and the Attorney General has to give advice on it and there are all these complicated things that you told us about yesterday, then what you could have done is you could have said, well, right, let us postpone, let us not have a date on the committee stage. But you would have restored the Labour bill to the order paper. Because in restoring the Labour bill to the order paper, you would have strengthened your own hand in government if your position was to ensure that this bill was going to be produced. And what has happened here, Chairman, Deputy Cuff, is that you've been codded. You've been codded by your partners. You've been codded into killing off the Labour bill because it does not appear to me that there is a genuine view being taken with your government partners to bring this legislation forward. You've also been codded, I submit, in respect of all of this stuff that we have heard about other forms of partnerships and about the Colley report. We're told that the government legislation for civil partnerships will now include civil partnerships to include cohabiting brothers and sisters. Now, I fully recognise that there is an issue to be addressed in terms of taxation and inheritance in such circumstances, but I insist, and my party insists, that this is not an issue for debate on this bill. The government says that it will draw on the Colley options paper and the recommendations of the Law Reform Commission on the rights of cohabitants. But there is one basic fundamental fact that is fully recognised in the Colley paper, but which this government still refuses to recognise. And that basic point is this: there are heterosexual couples who wish to cohabit, and there are gay couples who wish to cohabit. There are also heterosexual couples who wish to marry, and there are gay couples who wish to marry. The heterosexual couples have an option one way or the other, gay couples do not. The Colley Group recognised this point, and the Colley proposals are in stark contrast to the government proposals. What Ms Colley and her group said was that full civil partnership for same-sex couples, in contrast with opposite-sex couples, should be viewed as a distinct institution, separate from and not competing with marriage. And by the way, the Colley Group believed that full civil partnership for same-sex couples did not suffer the same constitutional vulnerability as full civil partnership for opposite-sex couples. What Colley said, and I would imagine that the Attorney General would have confirmed this, is that if equivalence is given to cohabiting couples who could get married but decide not to, as is given to married couples, then the institution of marriage is arguably being attacked and undermined. But as her group and as our bill recognises, if you are giving legal recognition to same-sex couples who cannot constitutionally marry, then what injury is being done to the concept of marriage? The bill which we have proposed is proposed on an analysis that accords with the observations of the Colley Group. We propose a civil registration scheme which extends the full range of rights and duties of marriage for same-sex couples. We agree, as they did, that there are no obvious additional benefits to introducing an alternative to marriage in the form of civil registration for opposite-sex couples, apart from offering a marriage-identical commitment without the marriage title to couples who object to marriage per se. We agree, as they did, that introducing such an alternative for opposite-sex couples is vulnerable to constitutional challenge. And like the working group, we are not convinced that there are many cohabiting opposite-sex couples who are unwilling to marry but may be willing to enter a registration scheme which has all the attendant obligations of marriage. Our bill is underpinned by one single overriding principle, the principle of equality. And as Deputy Howland wrote this morning, the principle of equality is at once simple and unsettling, often unwelcomed, yet ultimately unquestionable and undeniable. The principle of equality is founded on the bond of our common humanity. It is based on our recognition of each other as an essential shared human experience. To deny equality is to look another in the eye and to proclaim him or her a lesser person. It is to deny the bond of our common humanity. Deputy Mansur, I believe, has spoken the unspoken but real and reactionary mindset which is blocking the passage of this bill today.